Hello, my name is Sequela. I'm recording this video presentation for my business 343 class at Liberty University. We were required to choose from Chapter 9, choose a case from Chapter 9. I have chosen case number 3, and I will assume the role as a labor relations representative. The introduction. Safety gloves discharged with just cause. I will provide an overview of the case. Aaron McNamara was an employee of Barrera Recycling Company for approximately 20 years. McNamara was transferred to this facility from a Long Beach facility in January. Rafael Gomez, the general manager of the Los Angeles location, had numerous conversations with Ms. McNamara about her disregard for safety procedures. After numerous conversations, to be considered verbal warnings, Gomez gave McNamara a formal notice in the way of a 3-day suspension on October 28th. With the 3-day suspension, Ms. McNamara was also given a 12-month probationary period in which she was notified that violating the policy again would end in termination. Less than 3 months after the suspension and probation notice, Ms. McNamara was found to have violated the policy again and was subsequently terminated per the probation notice. Local 37 of the United Paper Workers International Union filed a grievance protesting the discharge of the employee, claiming that there was not just cause. I will explain what just cause is. I will discuss how we determine just cause and due process, and then I will discuss our position. What is just cause? An employer has just cause to dismiss when there is substantive justification and when the dismissal was handled in a procedurally fair manner. Article 10, Section 2 of the collective bargaining agreement between Barrera Recycling Company and Local 37 of the United Paper Workers International Union states the following. Discharge or suspension of an employee, not including a temporary layoff, shall be based on just or sufficient cause, with a full explanation given to the employee. One way to determine just cause is to show that the manager used due process to mitigate the employee's violating behavior before she was terminated. How is due process determined? Arbitrator Carroll Daugherty in 1964 articulation of 7 steps to determining due process and just cause set the standard for employers to follow to make disciplinary decisions. Daugherty states a no answer to the following 7 questions indicates that there was no just cause or due process. The next slides will state the questions and indicate that all questions of due process and just cause were covered, meaning we had a yes answer. The 7 tests of just cause and due process. Question number 1. Was the worker given advance warning of the consequence of her conduct? Rafael Gomez had many verbal conversations with Aaron McNamara regarding work performance and safety issues. After the 7th violation of company policy, Ms. McNamara was given a 3-day suspension that was not contested as a warning that any violation of Barrera rule or regulations during the next 12 months would end in discharge from employment. Number 2, was the rule reasonably related to the employee performance? McNamara repeatedly violated company policy directly related to her job performance and company safety policies. 2 conversations dealt with the employee sleeping through safety meetings. This is a violation of Article 20, Section 1, Number 10. Four other conversations dealt with employees' refusal to wear proper safety equipment: hard hat, gloves, safety glasses, um, safety gloves. The violated rules directly related to her job, and the fact that violating these rules could cause the employee harm and put the company in jeopardy. Was the alleged violation thoroughly investigated before discipline? Yes. Gomez questioned the employee. He asked her to explain why she did not have her safety gloves on. Her explanation was that her safety gloves were in her truck. Gomez determined that this explanation was not substantial. Was the investigation fair and objective? This is question number 4. The rule that was violated was an objective rule. The employee was given the chance to explain why she was in violation of company policy, safety policy. The employee was also well aware of company safety policy, as all other employees were wearing their safety gloves at the time of the incident. The 7th test of just cause due process continues. Question number 5. Did the investigation reveal convincing proof of guilt? After the Barrera Labor Relations Department investigated the termination, we have determined that there is convincing proof of guilt and that the client has been verbally and formally warned several times regarding safety violations. Although the verbal warnings are not documented, the fact that there was no dispute when the formal warning and suspension was given indicates that the verbal warnings were in fact given. Was the employer's discipline non-discriminatory? Discrimination is not an issue in this case. The employee was discharged based on objective observation of policy violations. Was the discipline reasonably related to the worker's record and the severity of the conduct? This is the final question. Barrera Labor Relations Department considered Aaron McNamara's seniority and recent transfer to the Los Angeles plant in our investigation. We have determined that with the client's seniority also comes the inherent knowledge of the company's safety rules and regulations. Also, the client was given a warning for several items that were subject to immediate discharge, according to Article 20, Section 1 of the Collective Bargaining Agreement. The warning included the notice that further violation would end in discharge from employment. Barrera Labor Relations Position and Plan of Action. The Barrera Recycling Company's Labor Relations Department, after a complete investigation, has decided to uphold Rafael Gomez's decision to terminate Aaron McNamara for failure to follow safety procedures. In our consideration of the employee's seniority of approximately 20 years, we will offer the employee a severance package in an effort to acknowledge the employee for her years of service. The severance package will be offered to the client in an effort to mitigate any financial hardship that the employee may endure. The conclusion. The Barrera Recycling Company's Labor Relations Department has determined that the employee, Aaron McNamara, was discharged based on just cause. Although the United States common law operates on an employment at will doctrine, the collective bargaining agreement between us and the United Paper Workers International Union requires that we discipline based on just cause. After thorough investigation and review of Daugherty's 7 rules to determine just cause, we have determined that this provision has been met. The just cause provision was put in place to protect the worker from unjust discipline and the company in arbitration. Before the termination, the client was made aware that violation of the company's safety policy would not be tolerated and would end in termination. Failure to follow through with this discipline could change the culture of the company and escalate into more incidents of disregarding safety rules. We also understand that this incident can alarm other employees with fear of job insecurity. We are attempting to mitigate this situation with a severance package to ensure our loyalty to senior employees.